I'd like to give the floor to Mr. Justice A.F.M. Abdur Rahman. He is one of those judges who are very close to the junior practitioners because he has the warmth and the welcoming arms to accommodate us whenever we frequent his court. And he has been presiding over the arbitration bench for quite some years now. So I would, sir, invite you to pick up the threads from the keynote presentation by Mr. Samir Sattars, in particular on the issues of our court's jurisdiction over both domestic and international commercial arbitration, and also to what degree you think the court intervention should be allowed, because this is not something peculiar to Bangladesh. Court intervention is a common feature of arbitration law wherever the seat of arbitration is, but our concern is how efficiently the court intervention can be managed under our legal structure. Thank you.
Well, Assalamu alaikum. The discussion, as has been made by the learned advocate Mr. Samir Sattar, regarding the development and the challenge of the arbitration law in Bangladesh, what we have picked up from there, that after the amendment, after the new law as enacted after the previous law, Arbitration Act 1940, a great section of business people are dissatisfied with some of the provision of the Arbitration Act 2001, especially the appointment of arbitrator and the interim measure to be obtained from the court. Why? Because it is not the provision that gave the party to come to the court. Rather, it is the prolongation of the whole proceeding in the court. You see, the interim relief that has been provided by Arbitration Act is a required one. Because if any of the party is prejudiced by the other side, the remedy only lies in the provision to come to the court or to the tribunal. But prior to any constitution of the arbitral tribunal, the law provides in 7A after the amendment that one can come to the court and ask for relief. And this is a very required provision. Unless this provision is in the law, one will be simply destroyed. The whole proceeding will be infructuous, will be frustrated simply. So this must be kept in the law. But why the people are dissatisfied with this provision? Because of the long delay in disposal of these applications. As a lawyer, he has rightly said that it is you. The mindset has to be changed. What is that? Some client came to the learned lawyer, asked for prolongation of the whole proceeding of arbitration, and he accepted the brief. Come to the court, file an application. After taking the order from this court in interim manner, he never comes back. All the applications are pending for years together. This is my experience, not my experience, also the experience of my brothers, especially His Lordship Mr. Justice Imam Ali is here. He has also presided over the arbitration bench, company bench, admiralty bench. My brother, Mr. Justice Said Fatah Ahmed. This is also the experience of other learned judges. That whenever a party comes to the court, he wishes to keep the proceeding pending for years together. And this goes to the responsibility of the learned advocates only. The court is always ready to dispose of the matters quickly. Because what is the aim and object of the Arbitration Act? It is to dispose of speedily the commercial dispute of the business people. But business people, if they see that the disputes as to their contract is not being disposed of within a short span of time, they will never be interested to invest in business concern. And that is the only difficulty with the investment not coming to Bangladesh. And as a court, it is my experience that we have frequently expressed our anxiousness about this matter, about the investment in Bangladesh. And this has to be considered not by the court, but by the learned advocates. The only remedy lies to activate the whole thing is to include a time frame in the Arbitration Act. What court can do, the court can itself, under its inherent jurisdiction, it can dispose of the matter within a short span of time. Because recently, what I have seen, we have 5 and 20 arbitration cases in the bench, and it has been disposed of very quickly, making high pressure upon the learned advocates. Now only 116 to 120 as the 120 cases are now pending regarding the arbitration matters. So a time frame will be a appropriate relief to the people, to the parties coming to the court, and it is not the amendment of the law in other manner. So from my experience, I can say that if a time framing provision is included in the law, then this harassment, these sufferings of the people, of the business people, will be much reduced. Thank you.
Thank you, sir. We'll come back to you later on other issues. Now I am moving on to Senior Advocate Barrister Akhtar Imam. Mr. Imam has acted as counsel and arbitrator in many international commercial arbitrations seated in Bangladesh, and he has a close-up feel about how the arbitration law works in Bangladesh. So, sir, I'm not going to suggest any particular topic to you, but may I request you to discuss the issues broadly, but also with a kind of a specific reference to how you feel our system caters for enforcement of arbitration awards which are going to be obtained by parties outside Bangladesh. Thank you. This is only one of the issues that you're going to discuss, and a few more.
Maybe the first point which I will take up on the basis of the observation made by my Mr. Justice Rahman, who should have the something. Hello? Yes, that's better. So, Shekhantai, with regard to the respective roles of the advocates and the judges, one interesting observation made by Shekhantai Shudi, if I may just say, that ultimate control of the court and the judicial process is with the judge, not the lawyers. The lawyers would always like to act on the basis of advice given by or instructions given by their clients, which is their profession. In the process, it is quite possible, and they do abuse the kind of role they otherwise have. One role being that he is simultaneously an officer of the court. But beyond that, I believe that the judge concerned has the ultimate power and authority to control any kind of abuse which the lawyers concerned of either side, as per instructions of their client, may like to take. Now, this kind of abuse is not unknown. But anyway, that's a point which I'm sure that we all have our views. But it has always been my view that right from the lowest court to the highest court, the control ultimately has to come from the judiciary. And they have the ultimate say in all that. Having said that, If I may be permitted to make some observations which will be fairly caustic and fairly radical, I hope that the learned audience would take it in the right spirit, particularly those who are the devout fans of arbitration as an alternative dispute resolution. ADR, as it has been popularly known, whether it is in the form of arbitration, mediation, or conciliation, whichever form it takes, it is popularly believed, it has become popular across the world in the recent past to settle primarily commercial and business disputes outside the traditional judicial system. And presumably, I am deliberately using the word presumably or allegedly for, among others, the following reasons. One is supposed to be the relatively expeditious form of relief. Arbitration or ADR is supposed to be an expeditious form of relief. And I will give you evidence of at least a dozen cases where I was personally involved, where instead of being an expeditious form of relief, it has taken 3 times the time which normally a civil court should have taken. I have one case which started in early 1980s, one of my very first cases after I came to this country. And would you believe this? This is still pending in the appellate division of the Supreme Court of Bangladesh. And it has taken 2002, I believe, was when I got the certified copy from the High Court. And High Court, it took about 6 to 7 years. I don't want to go behind that. But when it came to the appellate division, leave was granted, and from 2002, this is 2018. I do not see the light at the end of the tunnel. This was argued for 3 days, 3 full days. And judgment was reserved. That judgment never came during the last year and a half. My apologies. I do not wish to hurt anyone or any institution, but we need to take the responsibility where it lies. এখানে এই যে among others তারপরে it's supposed to be inexpensive and speedy. How is it inexpensive? If I have to have a client for 17 years, I'm going to charge him for every single occasion I appear on his behalf. The procedure is supposed to be informal. I have not come across one single arbitration where procedure was really informal. The witnesses are being exactly as in the case of a civil suit. Every single step was being followed. Whereas the law says that neither CPC nor Evidence Act applies to an arbitration. And this is section 24 of our Act, in clearest possible language. Yet we are always following both the Evidence Act as well as broadly the procedure laid down in CPC. And then other points are known to all of us, that it supposedly eases pressure on the civil judiciary, and that it's pre-litigation, arbitration, mediation, or conciliation, etc. Plus, during litigation these days, we have introduced, I don't know to what extent it has been effective in inserting these pre-litigation procedures like in CPC, where mediation and arbitration both have been introduced, and Orthorin Adalotain, Burke, and among many other acts. But how far this has succeeded so far in providing the remedy in the form or in the manner we expected, I have my serious reservations. we all know, from the keynote speech at least, that the model law, which was formed on the basis of this UNCITRAL resolution of 1985, and this was revised again in 2006. This was on the basis of a general consensus amongst most of the developed countries, at least, that there ought to be uniformity, harmonization, and unification of the national laws of all these countries. And there is gross disparity amongst the national laws. The inadequacies of the domestic laws and the wide discrepancies or disparity between the national laws are supposedly the principal reasons for the development or emergence of this model law. Now, even this model law has not been followed by many countries, including our neighbor as well as Bangladesh. Our keynote speaker has already mentioned a few, that where this model law provided certain things like scope of application, particularly with regard to interim measures, that it shall be irrespective of the place or the seat of arbitration being outside Bangladesh. Whereas এখন পর্যন্ত আমাদের one of the major reasons for the conflicting decisions in our High Court division, the last one being by my Lord Justice Mr. Fataham. Yes. So there obviously my Lord had to take sides. There were already two conflicting decisions, and there were two conflicting decisions of the Indian Supreme Court. And eventually Indian Supreme Court in Bharat aluminium case overruled its earlier Bhatia case. And that put the wrong balance. Here the balance went in favor of the HRC case, and that led to your Lordship deciding. And particularly in view of the wording of it, Section 3 is very clear. Unless the judiciary wishes to legislate, which we never do. Your Lordship will never do this. So even if it goes to the appellate division, I am not at all certain that it will produce a result which is different. In particular, this last Indian Supreme Court case made it absolutely clear, which was followed by your Lordship. So these are some of the problems which obviously amongst other countries, and developing or least developed countries, we have been facing. And I would like to put on record our more or less what sort of past record Bangladesh has with regard to this alternative dispute resolution, and why we have one of the poorest records in the world. And we all also know that it is a positive hindrance towards improving the investment climate or attract foreign investment. But why do we have such an unenviable record, even compared to our neighbors? May I just cite 4 reasons? First, it's the political and the executive influence peddling or control, which affects the appointment, removal, discipline, and transfer of all the judges, not mainly the lower court judges. And that this so-called independence of judiciary, we are all aware of the limits of that one. And what is this resulting in? It is resulting in an all-pervasive inefficiency and incompetence, just to put it mildly. And I will add to that list in the justice delivery system. Incompetence and inefficiency is also another very major reason as to why there is so much of delay in the disposal of cases in every single court. Then, my Lord, the overall unethical and the corrupt environment which is affecting the performance of the entire system. These are the twin cancers, my lord. I would like to call them the twin cancers of influence peddling and massive corruption. If not the aforesaid, what I said earlier, the inefficiency and incompetence, these have rendered the entire justice delivery system into virtual shambles and hardly anything to be proud of. We have got to address these issues if we are to go anywhere. Other than that, we are aware of the systemic or structural weaknesses or inadequacies, including the procedural lacuna, etc., in the arbitration law. And just one last point with regard to this is the complete failure so far on our part to impose what I would like to term punitive costs for instituting mischievous, frivolous, and dilatory litigation or arbitration. If we would have imposed this punitive cost, which is one of the methods applied in practically the entire Western world, which is a developed legal system, this is how they produce this disincentive on the part of these frivolous litigation. And once they are imposed hefty costs, not 1,000 taka as somebody said as cost, when he has spent 1 crore taka on the lawyer's assets. So, hefty punitive costs would certainly help in improving the system. Now, Akhtar, I have just a few, very briefly I would like to say, if arbitration is to survive, if not flourish in a country like Bangladesh as a viable ADR, at the very least, the following reforms or clarifications are extremely urgent, if not mandatory, in the Arbitration Act of 2001, in line with developments and revisions in the model law about which our keynote speaker spoke, model law and the parallel jurisdictions. We have to learn from them. And Shekhar, I have just a few such reform measures which may kindly be considered by the audience. First, this section 42 to 48 of the Arbitration Act 2001 deal with setting aside arbitral awards. 42 to 48. Section 42, 1 and 48, in my opinion, ought to be merged to set up a special exclusive High Court bench with comprehensive jurisdiction to deal with all domestic and local commercial arbitration. The High Court division may set aside an arbitral award in an international commercial arbitration held in Bangladesh and without any appeal under Section 48, except, as we know, that Section 48B and C deals with other matters. Thereafter, an appeal to the appellate division under Article 103, which unfortunately we are not able to do anything until there is a formal amendment to the Constitution. But if 103 is to be retained as part of the Constitution, then, sorry, keep on. Again, my Lord, preferably to a special bench thereof, if 103 is retained, and we have to retain it until there is a formal amendment, then there has to be a special bench even in the appellate division, exclusively to deal not merely with arbitration, but similar subjects which are of extreme urgency. তার জন্য যদি আলাদা না করা হয়, in the normal routine manner, I see my item in number 503. We shall take 6 years to 6 months to 1 year before I can even hope that it will be heard. আমাদের এখনো unfortunately যে we could have three benches which could explicitly deal with until matters. But এখানটায় unless and until these are given due importance, merely by talking about it, that this is an expeditious form of relief, will not serve any purpose. Then my learned Mr. Justice Abdur said, I agree, that there has to be mandatory time frame for disposal of each application or case, be it under Section 12 regarding the appointment or under Section 42. Section 42 and 12 both, as a matter of fact, provide a time frame, jeta holo 60 days. But who bothers about time frame? Who bothers? I have not come across one single case যেখানে 60 days এর মধ্যে আমার arbitrator appoint করা হয়েছে অথবা 42 তে dispose of করা হয়েছে. I have brought here যে 385 days, 385 orders of various courts in one single arbitration. I don't want to name names, but there is another case which is still going on. 40, it's above 40 days of hearing and application raising objection to an arbitration award. 42 days, 4 or 5 years. And we still call it an expeditious form of relief. And that is only the lowest court. That is only the lowest court. We have then the High Court, then the Appellate Division, then we have a review also. I am so sorry. But there are a few other recommendations. But to my apologies.
Thank you very much, sir. Thank you very much for your very passionate insights, and I'm sure the next speaker on the panel, Mr. Mustafizur Rahman Khan, has got enough ingredient to fill in his 10 minutes. So without any further introduction, Mr. Mustafizur Rahman Khan.
First of all, I do not intend to take 10 minutes. I'm actually reminded at this stage of Percival Spear's History of India, where he described Humayun as the hyphen which connects Babur with his much more illustrious descendant Akbar. I have a feeling, in view of the self-professed caustic remarks that have been made by my learned senior friend, Mr. Akhtar Imam, and the vigorous note-taking of at least one of the members of the audience, that I too will be a hyphen which will connect Mr. Akhtar Imam with a certain member of the audience. But before I relinquish that role as a hyphen, I want to say just a few words. I'm very encouraged by the fact that there are very younger members of the audience who are here, who are recently returned from England, many of them who have qualified from universities in Bangladesh with very good qualifications, and all of them are doing very well in practice. I seek their apology because much of what you may have heard during the course of the day may be cause of pessimism. However, I believe that you have a role to play here. One of the problems with arbitration in Bangladesh is that arbitration in Bangladesh is mostly ad hoc arbitration. In Bangladesh, we have not yet developed institutional arbitration to the extent that it has developed in other jurisdictions. And as far as Bangladesh is concerned, I believe that many of the weaknesses, many of the complaints that have been raised against the arbitral process in Bangladesh can be remedied if there is an institutional arbitration is encouraged in Bangladesh. The institution has its own rules which set down very particular requirements as to time frame. It also spells out very definitively the consequences that will flow if the time frame is not maintained, including the fact that the matter will proceed to an ex parte hearing, resulting in an award if the time frame is not maintained. I think that is one of the ways in which some of the problems can be cured very quickly without having to wait for the policy discussion to mature further for Parliament to take action. And to that, younger members of the audience, you have a role to play in the chambers that you work. Please engage with BIAC in particular, because we already have that institution in Bangladesh. Look at their arbitral rules, see how these can be improved. As a lawyer, while advising a client, take the lead in advising them to include suitably drafted arbitral clauses in their contracts so that we can trigger that mechanism. We also have amongst the audiences Mr. Barrister Khalid Hamid Chaudhary, for instance, who very recently has been qualified as a fellow or a member of the fellow of the Chartered Institute of Arbitrators in England. There are people in Bangladesh like him who are already educated in the process, who have accumulated wisdom in the process. And I think we should look to find ways in which we can benefit from their wisdom. Many of the complaints that have been made about the legal system actually hint at a very unique demographic challenge that Bangladesh faces. This is just 1 minute. Bangladesh may be the 8th or 9th populous country in the world. But Bangladesh is actually, think of it, the largest unitary democracy in the world. All the countries which have a greater population than Bangladesh are actually federal systems. So we have only one Supreme Court. We have only one apex judiciary to which everybody comes forward for redress. So and this is a word of empathy that I have for the judges in view of the perhaps attack that has been launched from this end a little while ago, is that my apologies, sir. No,
we're both on the same side.
We
fight the same battles.
We fight the same battles.
Bar on the bench should not be seen.
Then let me correct myself. We, the legal system of Bangladesh, the judiciary and the bar, the challenge that we face, the demographic challenge that we face in delivering a service is unique. It is without a parallel in any other country. Leaving aside all the politics, all the corruption issues, but structurally, I think that there is considerable scope of discussion, and that discussion has to happen beyond the parameters of a discussion on arbitration. I think that is a discussion which should be in the context of constitutional reform. That is all that I have said. I have to say. Thank you.
Thank you very much. I have about 5 minutes left from the panelists' time. So I would come back to Mr. Justice A.F.M. Abdur Rahman. I think it would be only apt if we provide an opportunity to Mr. Justice Abdur Rahman to provide his insights as to how the court intervention can be made more efficient, because suggestions have been made regarding putting a cap on the time and awarding costs on the losing side. And also, could there be a dedicated bench for dealing with arbitration matters? Thank you.
Oh, no. The arbitration matters are not that much of only few matters are arbitration matters. It doesn't require any dedicated bench. But so far the question of the act on the part of the court is in concern. The court must see whenever an application is filed and the admission hearing is taken, the court must see that whether the application is a frivolous application. That is the first thing to be seen by the court, but to be considered. Then, if the order is passed, whether the interim order will prejudice the other side, in a very prejudiced manner. That will be the second consideration of the court. And the third consideration, that one must be cautioned on the spot that you are to finish this application within certain time. And since the bench who has passed the order, admitted the application, will hear the matter, the bench should make up the provision for hearing that matter. These are the things to be taken by the court itself. Because whenever the court has heard the admission matter, the court is aware of the fate of the application, what it will happen. Only to allow the other party to come to and place their case, the court has given the time. So one application must not take more than 30 days or at least 45 days. So the court should give a time frame apart from the proposal for amendment of the law for inclusion of any time frame. The court should see that the application must be concluded within 1 month or 1.5 months. Because the service of notice requires only 7 days. So after the 7 days, the other party should come. One thing must be considered by the court, that a tribunal is waiting for the decision. A tribunal is waiting for the adjudication of the arbitral matter. So if the court takes the whole time, then the whole thing goes in vain practically. Another thing, whenever a matter comes to the court, suppose an application under Section 12, appointment of arbitrator. If the court adjudicates the whole cause, what is the provision of law? It is only to see that whether there is an arbitral dispute and whether provision of law has been followed by the parties. Then court will pass the order. If the court starts adjudicating the whole thing, whether the arbitral cause has a merit or whether the arbitral cause should be allowed, then the job of the arbitral tribunal is being done by the court. And we, sorry to say, we have seen in the last few past days that it has been done. The court has decided whether there is arbitral cause, and that arbitral cause has merit. So these are the things, if the court takes into consideration, I think the arbitration application will be disposed of with a very short span of time. Thank you.
Thank you very much. Thank you very much, sir, and to all our panelists. And may we now invite the audience to pose questions to the panelists, and members of judiciary can make remarks on the issues that have already been discussed.
My question is to Mr. Mustafizur Rahman Khan in particular. Is this right? Mr. Khan, I know you may have argued on this point many a times, and Mr. Akhtar Imam has, I suppose, as well. At the point in time that Section 7A was introduced into the Act, what was the missed opportunity, do you think, for the record to revisit other existing sections in the Arbitration Act, primarily Section 3, to tide us over this quandary that we find in terms of a bar in dealing with arbitrations, with seats of arbitration outside of Bangladesh? What was the missed opportunity?
It's actually very simple. I think in Section 3, there is an exception. The exception is that when it comes to enforcement of foreign arbitral awards, the enforcement of a foreign arbitral award, the courts in Bangladesh have a jurisdiction. I think that when the 7 Q was inserted, I think a suitable amendment should have been made in Section 3 as well, to say that with the exception of Section 7 Q, 44, 45, so on and so forth, so that both the enforcement aspect of it as well as interim measure protection aspect of it could have been catered into. I think another thing could have been introduced in the law in order to limit the court's interference with the foreign arbitral proceedings. The provision for interim order could have been very expressly made very limited in its application for a period of 30 days or 60 days, so that the parties have an opportunity to invoke the appropriate jurisdiction in the country where the arbitration is hosted and obtain interim measures suitable, if allowed by the seat that they themselves have chosen for the arbitration, and thereby give effect to the contractual intention of the parties. So I think that is what has been missed.
And in the list of provisions, you have mentioned 7A. I think Section 10 should also have been considered.
Yes.
To
all
prevent
the
parallel proceedings.
All the provisions where the court has an opportunity to interfere with the domestic arbitration may also be expanded to allow intervention in case of an arbitration which is situated abroad, but with certain limits for a period of 30 days, 60 days, so that a party can rush to the foreign arbitral forum and obtain necessary interim orders.
Thank you.
As a matter of fact, certain modifications were brought by the ancestral model law. And one is this, that it shall apply, any interim measure shall apply irrespective of the place or seat of arbitration being outside Bangladesh. That has not been adopted as yet. Number of reforms were possible and still is possible. But we have to adopt these things. Without adopting it, leaving it to the judiciary and in order to legislate, obviously is not the answer. As your Lordship said quite rightly, it's not the appellate division's job to find an it's otherwise so clear. And it has already been dealt with extensively by 2 Supreme Court judgments in India. And obviously which were considered duly by your Lordship. So, Okantai, I believe that reforming of the Act itself, it could have been and should have been done, I'm telling you, in 2004. But it's never too late. It's 2018. We have waited 40 years for one arbitration to finish. So what does it matter really? Another 12 years or so.
Let us take a few more questions and then.
But শুধু আমি একটা কিন্তু পয়েন্ট আমি অ্যাড করব একটা যেটা বললেন হচ্ছে টাইম ফ্রেম may become a meaningless exercise. These are always considered to be directory and not mandatory. Supposing that the particular court fails to deliver within the time frame, it does not appoint the arbitrator or does not dispose of a case which is to be disposed of within 60 days. What happens then? Does it go to what sort of provision we can make with regard to this failure? Shall we have any kind of, what you say, disciplinary action to be taken against a particular court concern and send the case to some other court with another given time frame? And these are problems which we have to address. যে এই টাইম ফ্রেমটা বলেছে যে টাইম ফ্রেম দেওয়া উচিত, it will be there, but no one follows. And সেখান থেকে আমি বলেছিলাম যেটা যে your lordships are in a position to impose it. That follow this at your, otherwise it is at your peril that you do not follow. Default order. Straight default order.
So
and then the grounds, there are a number of areas in which the Act can certainly be improved. The grounds of challenge or objection. We got any second everything under God's earth. Public policy is just one. And public policy, one can spend days on what is public policy in a given context.
Sir, I propose that we take a few more questions and then come back to these issues. Would any member? Yeah, I can see hands at the back and at the front. Mr. Ashraful Hadi. He raised his hand before.
Hello. Thank you. Today's topic was international arbitration, and one of the topic was challenges. One of the problems that we face as counsels, as lawyers, was that the Arbitration Act talks about recognition and enforcement of arbitration award, international arbitration award in particular. But the process or procedural law for enforcement or execution of the arbitration award involves filing of an execution proceedings under the Code of Civil Procedure. And to do so, we have to fill out a 110-year-old a form that was set out under this Code of Civil Procedure 1908, a one-page form that has to be filled in for commencement of the execution proceedings. And one can look at it and see that that 110-year-old form doesn't live up to the problems and the commercial realities that we face under particularly an arbitration award. That form was not updated in the year 1940 when the Arbitration Act 1940 was passed, and it has not been also been updated in the 2001 or after the amendments to that. So the execution proceedings in effect creates a procedural problem. That's one. And so that's, I would like to draw your attention of the panel. And secondly, it requires a list of assets to be filled in within that 60 days of period within which the arbitration award has to be filed. I mean, there is no process or procedural law that accommodates for putting out those informations at a later stage. And thirdly, this is my question to Mr. Justice A.F.M. Abdur Rahman. Regarding the time frame, until the Parliament passes the time frame, is it possible for example, in England, we see judicial directions being passed from the appellate division as administrative orders for the benches that are dealing with arbitration matters, to pass a directory notes or direction notes as to which the arbitration courts can take with, and therefore the lacuna may be filled in through such directory notes that it has to be disposed within 30 days or 60 days and so on and so forth. Is it possible to introduce those notes? Thank you.
Thank you. One more question from the back, please. Please introduce yourself and keep the question brief and one at a time.
Assalamu alaikum. I am Suhan Khan from Echo Chambers. Well, basically, before posing my question, I would like to state one thing. That is, one of the key challenges which we face as practitioners in this jurisdiction is regarding the enforcement of foreign arbitral awards. And what we have seen is when an arbitration award is almost being passed or has been passed, what our colleagues or local clients, they do is they file a title suit in the district court challenging the pendency of the arbitration or the validity of the arbitration award on grounds of public policy, which my brother, Mr. Sattar, has already agitated. My lords, my question to His Lordship, Mr. Justice A.F.M. Abdur Rahman, is what can we as practitioners expect, that how can we refrain these sort of satellite litigations which are specifically aimed at preventing enforcement of foreign arbitration awards in this country?
Thank you.
I'll be short. The first one, the form. The form is of 110 years old, and the form is a universal one. This has not been classified for the arbitration or for the civil matters or for the other matters or for the loan giving matters. So the legislature can see the matter. They can reform this form, and it can classify the form for the arbitration and also for the other purpose. That has to be done by the legislature. It has got nothing to do by the courts. But so far the question of time frame is concerned, you know, we have introduced a system in the High Court Division rules that is called practice direction of the Chief Justice. Honorable Chief Justice may give the practice direction as to the time frame of the arbitration matters, or in any matters he can put a practice direction directing the courts to follow certain procedure other than the procedure that has been done in the High Court Division rules and other things, conforming the rules and other matters. So this can be done by the bar. They can approach the Honorable Chief Justice for any practice direction, and accordingly the Honorable Chief Justice may pass the practice direction. So for the question of the execution of the arbitration award, foreign arbitration award is concerned, you see, unless the law is changed, the court has nothing to do. The court cannot legislate. Court can only follow the law. The law is that you are to file the application before the court, and accordingly. Court and the High Court Division. It is classified. Court is the district court, and High Court Division is the High Court Division. And execution is only only there, not in the High Court Division, but in the. But so for the question, the filing of another suit, challenging that arbitration, that is the matter to be brought before the court concerned. The notice of the court that it has already been disposed of by way of arbitral award. So that is the merit of the matter. If a suit has been filed, that will be the plain to be rejected, whatever it might be, the other things can be done. So that is within the law. That provision is within the law. Then nothing, no new provisions required to be included in the matter. But so far that question comes about the form and about the other things. This can be remedied by so far the form is concerned by the legislature. So far the time frame is concerned, that is by the Honorable Chief Justice by practice direction. And ultimately, and at last, the court has to see whether this matter should be disposed of, because court is a welfare entity.